A resident in Slough has come forward with a deeply troubling story. They say they were forced to pay nearly £1,000 more than a court-registered debt. This wasn't a small error. The difference was a staggering £946. It's a classic David versus Goliath, pitting an ordinary family against two powerful enforcement companies, Civil Enforcement Limited, Direct Collection Bailiffs Limited. This story isn't just about numbers, it's about the immense pressure and fear families can face when confronted with aggressive debt collection tactics. It highlights a system that many feel is broken and urgently needs fixing for the protection of consumers. The core of this issue is a simple but shocking calculation. The family paid a total of £2,198 under duress. However, after the ordeal, they checked the official court records. The registered High Court writ of control was for only £1,252. This leaves a massive £946 gap. Where did this extra money go? What was it for? The family says they were never given a clear, itemized breakdown of these additional charges. This lack of transparency is a huge red flag and raises serious questions about the fees being levied during the enforcement process. The whole distressing saga began with a single parking charge notice. The notice was issued by Civil Enforcement Limited. It claimed a car had been parked on double yellow lines. Right from the start, there was a problem. The resident had sold that specific car months before the alleged event. They had the proof of sale. They had done everything by the book. They were no longer the registered keeper and therefore not liable for charges. This fundamental error should have been the end of the matter, but it was only the beginning. Despite the clear mistake, the letters kept coming. The resident did what any responsible person would do. They tried to appeal. They sent letters. They attempted to call the phone number provided by CEL. They explained they didn't own the car anymore, yet their appeals were seemingly ignored. The phone line, they report, was never answered. Eventually, a letter arrived stating their appeal had been rejected, with no explanation. Appeals systems can feel like a brick wall, designed to frustrate you into giving up and paying. They contacted Slough Borough Council about the location of the alleged infringement. The council's response was a game changer. They confirmed the land in question was council-owned, and a ticketing officer said a private company like CEL had no legal authority there. This meant the original charge was likely invalid from the outset. After the ignored appeals, the case was escalated. It was passed to an enforcement firm, Direct Collection Bailiffs Ltd, operating with High Court powers. This is where the situation went from a frustrating administrative battle to a frightening, real-world confrontation. One day, an enforcement agent arrived at the family's home. Without warning, the agent clamped the family's current car, which was a completely different vehicle from the one named on the original parking notice. This action immediately raised the stakes and increased the level of intimidation, putting the family on the back foot. The resident says the agent gave them no time to explain the history of the case or present their evidence. The demand was immediate and absolute. The agent allegedly stated the family owed £2,198. They were told if they did not pay in full, right there and then, their car would be towed away and eventually sold. This is a high-pressure tactic designed to provoke fear and panic. Losing a car can mean losing your job, losing your ability to take children to school, losing your independence. This entire confrontation happened in front of the residents' young children. They described the agent as shouting and being aggressive, creating a terrifying atmosphere. The children were visibly distressed. One child began to cry, asking if they were going to lose the car. No family should have to endure such an experience in their own home. Section 4, the human cost, fear, debt, distress. The financial damage to the family was immediate and severe. By paying the £2,198 demanded, their bank account was wiped out. They were left with no money for essentials: buy food, pay household bills, cover their rent. For many families, an unexpected expense of over £2,000 is simply catastrophic. The enforcement action didn't just collect a debt. It created a new crisis for the family. plunging them into financial precarity. Beyond the empty bank account, the emotional harm was profound. The family describes being left in a state of shock after the enforcement agent left. The children had trouble sleeping, haunted by the fear that someone could come and take their things away. The incident eroded their sense of safety and security. Parents were left with constant stress and anxiety, trying to manage the shortfall while also comforting frightened children. The consequences of aggressive enforcement go far beyond the money. It affects mental health, family stability, the well-being of children. The resident felt humiliated and helpless, forced into a corner in their own home. The lack of a clear breakdown for the extra £946 only added insult to injury. Section 5, Fighting Back. The call for reform and your rights. This distressing story is a clear and urgent call for reform. The system as it stands has too many gaps that can lead to families like this one suffering. We need clearer rules governing private parking companies. Why was a firm able to issue a ticket on council land? Why were legitimate appeals ignored? We also need much stricter oversight of the enforcement industry. The powers granted to High Court enforcement agents are significant, and with that power must come greater responsibility and accountability. The fees they can charge are set in law, and any deviation needs to be rigorously justified and transparent. Public awareness is just as important as regulatory reform. Everyone needs to know their rights when faced with a parking ticket or an enforcement agent. It was only after the event, by checking with the court, that the resident discovered the £946 discrepancy. Imagine if they had known to ask for a full breakdown of charges and proof of the writ of control on the doorstep. So what are the practical steps you can take if you find yourself in a similar situation? First, document everything. Keep every letter, every email, every receipt. Note every phone call, the date, the time, and who you spoke to. If an enforcement agent visits, try to stay calm and ask for their ID and proof of their authority. Always challenge what you believe is wrong. Seek help from citizens' advice or consumer rights groups and ask for a full written fee breakdown before paying. Check that the fees comply with the legal regulations. By demanding transparency and fairness, and by knowing our rights, we can ensure no other family has to pay nearly £1,000 more than they owe.